Hello and good day everyone, especially to you, Sergio Miscobel. The topic for today is all about the customs administrative proceedings. Definition of customs administrative proceedings. Customs administrative proceedings are the measures performed by the customs administration to implement the customs laws and regulation, including procedures for assessment, collection, and dispute resolution in the set of the formalized action and procedures carried out by the customs authority to ensure, enforce, and ensure to compliance with the national and international trade laws, regulation, and policies governing the import, export, and transit of the goods across international borders. Number two, legal basis. In the Customs Modernization and Tariff Act, or SAMTA, was passed in 2016 as the part of the Republic Act No. 10 and 63. The enforcement of the customs law, rules, and regulation is the part of the full legal framework of the customs administration that the SAMTA offers. In the Customs Administrative Order No. 10-2020, this order describes the steps involved in the handling products that comply with the customs rules, including the filing of complaints, holding hearing, and appealing decision. It also to revise uniform rules and administrative issues in the civil service, guarantee to due process and consistency in the handling of the case, in a particularly those pertaining to the customs administration. In library jurisdiction, the same day is the cornerstone of the Philippines customs law, laying forth the rules governing customs operation, enforcement, and sanction. It also the revised uniform rules on the administrative case also guarantee that due process the uniform procedures are the following in the administrative process, including those in the customs industry. Example, seizure and forfeiture procedures. Customs officer may issue a notice of seizure and begin a forfeiture procedures to seize commodities that are discovered to undervalued or misdeclared. In the same day, and also the KO 10-2020. In the administrative disciplinary actions is the legal framework to ensure the customs administrative action in the Philippines are carried out fairly to transparently and aligned with existing laws and regulation. Parties involved. Number one, Commissioner of Customs. Number two, District Collector. Number three, Intelligence and Investigation Service. Number four, Importer, Exporter, and Consignee. Number six, Customs Broker. Number six is the Legal Representative, Customs Adjudication Division, and Court of Tax Appeal. Different stage of the proceedings. Customs procedures are usually involved in several steps from the first declaration of the goods to their final release. This process is essential for the ensuring compliance with the national and international regulation and managing the flow of the goods in the international borders. Number one, import declaration. The process begins, the importer submit the declaration of the goods being brought into the country. The declaration must be submitted to the appropriate customs authority within the current time frame. Number two, assessment of duty and taxes. Is the customs authority to assess to the value of the goods and determine appropriate of the customs duties and taxes. And the import declaration may be involved to valuation methods such the transaction value or other rules determining the value of the goods. Three is the customs inspection examination. Customs authority may choose to inspect the goods to verify the declaration with the compliance with the customs regulation, security standard, and health and safety laws. Number four, release of goods once of the custom duties and taxes and in the regulation requirements are satisfied and under necessary inspection are required, the goods released for distribution of future handling. Number five is a post-clearance audit and compliance. If the importer dispute in any action taken by the customs authority, they can typically appeal to the authority or customs tribunal. And also if after goods have been released to the customs conduct a post-clearance audit to ensure the regulation has been adhered to. Number 6, appeal. If the importer may need to provide additional documentation or arguments to support their case. And the last is the customs clearance for the export if applicable. If some cases of the goods may need to export, if were temporarily imported for the repairs for the other reasons. Number 5 is the rights and responsibility. Number 1 is right to fair hearing. The parties to have the right to fair hearing to need the opportunity to present their case and defend their interest. Number 2 is right to legal presentation if the allowing to seek to advise the system for the legal professional. Number 3 is the right to appeal if the decision made by BOC to seek review by the higher authorities. Obligation to comply with the customs laws, if including paying duties and taxes and providing accurate information. Number 5 is obligation to the keep records, if the records to the import and exportation transaction which may be required for the audit purposes. Number 6, obligation to cooperate with the BOC administrative proceedings to provide necessary information documentation. Number 7, the right to claim refund, if the refund of duties and taxes paid if the entitled to it. Number 8, if the right to protest, decision made by the BUC seeking review by the higher authorities. Potential outcomes or penalties that may be result from the proceedings. When a violation occurs, different consequences or penalties may be applied depending on the nature and severity of the offenses. And these penalties are principally defined in the Customs Precision and Tariff Act or CMTA and its accompanying customs administrative orders, like possible result and penalties, fines, surcharges, critical error, and misclarification. Number 1 is the minor errors. Number 2 is the purposeful and fraudulent misclarification. Number 3, administrative penalties. Number 4, abandonment of goods. Number 5, legal action. And relevant timelines or deadline. The customs administrative proceedings are to govern strict the timelines designed to ensure effective while safeguarding rights for all customs authority affected parties. Number 1 is the annotation and the notice issuance, public consultation and hearings, decision issuance, appeal and review process, and the last is the case scenarios to illustrate the process. Number 1 is the pre-arrival of the goods. Number 2, lodging of the declaration after the arrival of goods. Number 3, submission of the goods declaration to the BOC. Number 4, review by the customs officer. Number 5, if the goods has corrected duties, taxes, duties correction. Number 6, assessment of goods. Number 7, inspection of goods. Number 8, payment of duties and taxes. Number 9, waiting for the releasing of the seizure. Number 11, delivery the goods into the importer. Number 12, keep records of importation for the post-clearance audit in the 3 years. Number 13, the customs officer sees the SHASH dispensee after importation, they will impose fines or charges. And the last, if no such problem and the goods will be in the good condition.